Welcome to Grow with Nitish channel. If you are new to the channel, kindly subscribe the channel, like the video and comment below about the video. You can also purchase the course made by me from Udemy. The name of the courses are shown on your screen. Let me read it for you. Learn drafting commercial contract, legal research using Google for lawyer law student, Adobe Acrobat Pro DC for lawyer law student. So in this video, I have explained about Bioplater clause, which is a part of drafting commercial contract course. You can purchase the course from Udemy if you like the video along with all the reading material. Now let's talk about boilerplate clause. So boilerplate clause are routine clause appear in almost all sort of business contract. These clauses are often overlooked as these clauses consist of general information repetitive in all sort of business contracts. These clauses play important role while drafting, but the client often fail to discuss these clauses in great detail with their draftsman. But when the dispute arises between the parties, the boilerplate clause often play important role. Let's see some of the example of boilerplate clause. So arbitration clause, jurisdiction clause, choice of law clause, escrow clause, these are some of the example of boilerplate clause. Caution while drafting boilerplate clause. While drafting boilerplate clause, often draftsmen ignore their client interest. The draftsman copy-paste such clauses from one agreement to another, as they consider it as an unnecessary clause. In case of dispute between the parties, the proper incorporation of boilerplate clause in an agreement often play a decisive role in protecting client interest. Importance of boilerplate clause. So boilerplate clause often helps in serving client fate in case of dispute between the parties. When the dispute arose between the parties often begin to search for minute detail in an agreement. If boilerplate clause properly drafted, the draftsman can best serve their client interest. Now let's see each boilerplate clause in great detail from the next lesson. Assurance clause. For successful execution of the agreement in timely manner, parties require a lot of assurance from one another. Parties need various kind of information like document, letter, etc. to successfully execute the agreement in timely manner. So by incorporating assurance clause in the agreement, the parties assure each other that they will provide all necessary information for successful execution of the agreement in time-bounded manner. Through this clause, the parties exert pressure and commitment from each other. Often in the absence of assurance clause, the parties try to escape their obligation in the agreement. Precaution to be taken while drafting assurance clause. So don't put unnecessary information in the assurance clause as it will increase unnecessary burden on the parties. The assurance clause should be based on merit and it should be reasonable as per the term and condition of the agreement. Example of assurance clause. So let's see how we will write the assurance clause in an agreement. So me read it for you. The parties shall perform all necessary act for the execution of this agreement. The parties further shall provide all necessary document to other parties for reasonable implementation of this agreement. So in this way you can write assurance clause in an agreement. No set off and counterclaim. Both the no set off clause and counterclaim clause are used in the agreement to protect the interest of the lender. Such clauses are common in loan agreement or financial agreement. Let's see the importance of these clauses. So basically these clauses are added to protect the interest of the lender in financial agreement. The borrower often tries to set off the amount due to lending party against such claim by the borrower. Often in case of delay in disbursement of loan, the borrower tries to set off and raise counterclaim toward the damage suffered by the borrower. So by adding this clause, you assure the lender that borrower has no right to withhold the payment and the borrower has to make full payment in all conditions to the lender without setting off any amount. However, in case of dispute between the parties, the court can entertain the counterclaim or set off application of the borrower on merit and can decide the application. Then the borrower has to pay as per the judgment of the court. Let's see this example. Let me read it for you. The borrower shall have no right to set off or counterclaim in respect of any claim, debt, or obligation against the payment of the benefit of the lender provided in this agreement. So, in this way, you can draft a set off or counterclaim clause in an agreement. Reliance and no reliance clause. Reliance clause means the parties are relying on each other document, especially provided during the execution of the agreement. And no reliance clause means parties are not relying on each other document, it is relying on only on the content provided in the agreement. Now let me read this reliance and no reliance clause for you so that you can understand it easily. Reliance clause. This clause shows that the party to the agreement relied on each other document, especially in the case of the loan agreement or other transaction. In case of taking loan by a corporate entity, the lender rely heavily on the borrower, which include document given by the borrower like warranties, account of statement, representation, etc. Since it is not possible for the lender to verify each and every content of the document of the borrower, to some extent the lender will verify the content and to some extent he has to rely on the borrower. It is also the duty of the borrower to give the correct document before taking any kind of loan. Hence, by inserting reliance clause, the draftman assured that the lender relied on the genuineness and correctness of the document produced by the borrower. Now let's see no reliance clause. So no reliance clause is inserted in an agreement where the parties don't want to bind each other toward any information, opinion, statement, etc. Reliance is placed on the document incorporated in the agreement only. There is no reliance on the document not incorporated in the agreement. Now let's see how to draft reliance clause. So let me read it for you. The director or the officer of the company shall rely on the information, opinion, report, etc. presented to them by any of the employee of the company or committee constituted by the company. The director or officer of the company must reasonably rely on that employee which provide him information report as per their professional capacity. Now let's see how to draft non-reliance clause. So let me read it for you. The parties to the agreement don't rely upon the presentation or statement not made herein this agreement with regard to any subject matter. So in this way you can draft reliance and no reliance clause in an agreement. Notice, in every commercial agreement, communication between the parties is important. It helps in fulfilling the contractual obligation as well as enforcing the right of the parties. It can be in the form of notice, mail, etc. Because of this informative notice clauses inserted in the agreement. Let's see some of the important details that notice clause should have, like name of the parties, designation of the parties, address of the parties, email ID or other relevant details which is related to notice. Also kindly mention the mode of delivery of notice in the notice clause. In case of any change in details of the notice clause like email, address of the parties or other relevant detail, then kindly inform the other party immediately. You can also mention the assumption of notice like the notice will be deemed to be served after 15 days from the dispatch of the notice. So when the notice is delivered, then after 15 days it will be deemed to be the notice has been served. Let's see an example of how to write the notice clause. Any notice under this agreement shall be given in writing and shall be delivered by the following mode only: by personal delivery, by staff, by courier, by registered email ID. Notice shall be sent to the firm official address only and to the distributor to the registered address only. So in this way, you can insert a notice clause in your agreement easily. Publicity. Commercial relation between the parties arrive only after tough negotiation. So after tough negotiation, each party wants to protect their interest. It often happens that the smaller parties try to show off its commercial relation with bigger parties for publicity to promote its own business interest. Also, the smaller parties get advantage of this publicity. Because of this reason or any reason for the time being, confidential clause is added in the agreement so that the term and condition between the parties remain confidential. Breach of confidential clause is an offense. The non-breaching party can always sue the breaching party in case there is confidential clause in the agreement. Let's see this exception. It is mandated to provide information even if the confidential clause is there in the agreement if the law enforcement agency require or law requires. Let's see how to draft confidential clause in a agreement. Each firm has a good reputation in the market. No firm shall disclose any information regarding commercial relation with a third party. Disclosure as per law is permissible by each of the firm. In case of disclosure with third party, prior written consent is needed from the other party. So in this way, you can draft confidential clause in an agreement. Severability of provision. It basically means if some of the provision of the agreement is illegal or unenforceable, then it will not affect the other provision of the agreement. The other provision will be legal and enforceable. So let me read this for you so that you can understand it easily. So this clause is added to protect remaining provision of the agreement in case of any provision is declared invalid by the court or some other reason like against the public policy, against the law itself, etc. Let's see this example. If the mode of payment is prescribed by check and suddenly the government banned the payment by check, then in such case the provision regarding the payment of check is invalid and rest of the provision is valid. Now the parties can renegotiate the invalid provision to make the agreement in compliance with the law. In this example, the payment mode is invalid as it has been banned by the government. So the payment clause or the payment provision is invalid. Now the parties has option to amend the payment clause or provision so that it can comply with the new law. Now let's see how to draft the severability of provision clause. Let's see this example. Let me read it for you. In case any provision of this agreement is declared invalid by court, then it will not affect the rest of the provision. The parties will renegotiate the invalid provision to reflect the original intent to the extent legally possible. So in this way, you can draft severability of provision clause as per your needs. Governing law and jurisdiction clause. Basically, governing law and jurisdiction clause helps in deciding the parties which law will be applicable in case of dispute between the parties. This clause helps in speedy adjudication of dispute between the parties. Now let me read it for you so that you can understand this clause easily. In almost all the countries in the world, there is arbitration law in each country. The name might be different in different countries, but the law might be similar. Arbitration law gives freedom to the parties to choose the law of governance and enforcement of their right and obligation of the party in case of dispute under commercial agreement. So, governing law and jurisdiction clause is applicable only in case of civil and commercial agreement. It is not applicable in case of criminal agreement. Importance of governing law and jurisdiction clause. Especially in commercial relationship, parties to the agreement have freedom to choose law of governance of any country in case of dispute between the parties. This law of governance helps in deciding the right and obligation of the parties in case of dispute. Therefore, in case of dispute arise between the parties, the first question is which country's law of governance is applicable. Let's see about transnational parties. The importance of this clause rises in case of transnational parties to the agreement, as the parties execute agreement in one country and perform their obligation in another country. Then in such case, various legal system has complete or partial jurisdiction to entertain suit filed by any of the parties. Therefore, it is necessary that the parties are unanimous regarding governing law and jurisdiction clause while drafting commercial agreement. Now let's talk about the factor that helps in deciding governing law and jurisdiction clause. Parties are free to choose their law of governance and jurisdiction, but this choice is not unfettered. The governing and jurisdictional law must have some connection with the agreement. So keep the following point in mind while drafting the governing law and jurisdiction clause, like the place where the agreement is executed, place of performance, place of domicile, residence or business of the parties, national character of the company, corporation involved in the transaction, subject matter of the agreement, other factors. Now let's talk about the consequence of failure to mention governing law and jurisdiction clause. So in the absence of governing law and jurisdiction clause, the place of performance of the agreement plays important role in deciding the governing law and jurisdiction clause in case of dispute between the parties. Now let's see how to draft these clauses. So let me read it for you. This agreement shall be governed by accordance with the Indian law. The parties hereby agree to submit all the dispute to the exclusive jurisdiction of Singapore court. So in this way you can draft governing law and jurisdiction clause in commercial agreement. Waiver. Waiver clause is helpful especially in a case where there is delay or failure by any of the parties enforcing their right and obligation. Simply delay or failure by any of the parties in enforcing their right and obligation does not amount to waiver of any right, obligation and remedy. Waiver clauses are incorporated in an agreement to ensure that the parties' failure to enforce contractual obligation either intentionally or by oversight does not amount to waiver to any right, obligation, remedy for its breach. The breach also does not absolve the parties from future default. Now let's talk about the importance of waiver clause. So waiver clause is added in an agreement so that parties can enforce all their right and obligation in a timely manner. Because sometimes the party either intentionally or by oversight forget to enforce their right and obligation. Also in some cases the party perform their respective right and obligation after some delay. Also note that the non-defaulting party can waive off the penalty agreed to be paid by the defaulting party in case of breach of any right and duties, but the penalty must be mentioned in the agreement itself. Now let's talk about the role of waiver clause on future compliance. Basically, waiver clause means deviation from the strict compliance of contractual agreement in the past does not absolve the parties from strict compliance in the future. So in other words, if the parties has been deviated from the strict compliance in the past, then it doesn't mean that they don't comply with the future agreement. Let's see the role of waiver clause and extension clause in an agreement. So by adding the extension clause in an agreement, the parties can extend the time period of contractual compliance. And by combining the waiver clause and extension, the parties can manipulate the compliance in contractual agreement. For example, the parties can waive up the compliance explicitly, but such waive off will depend upon other provision of the agreement. Let's see type of waiver. So basically there are 5 type of waiver, and let me read how we will draft each type of waiver in the agreement one by one. So the first is simple waiver. The waiver by company of a breach of this agreement by director will not be deemed to be as waiver of subsequent breach. The second is affirmative waiver. Parties' failure to enforce any right under this agreement will not deemed to be waiver of parties' right. Written waiver. Waiver or extension in this agreement shall be considered granted by the party if it is in writing and has been approved by the other party. General waiver. Failure of enforcement of any right by the party will not be deemed to be waiver of that right or subsequent right. No course of dealing waiver. Partial exercise of right shall not preclude other party of that right or any future right. So in this way, you can draft waiver clause in commercial agreement. Assignment and transfer. Assignment and transfer basically means assigning and transferring the right and obligation of the parties to the third party. So before incorporating the assignment and transfer clause, first we have to check whether assignment or transfer of right and obligation of the parties are permissible or not in the agreement. Now let's see the Relevance of assignment clause. So by incorporating the assignment clause in the agreement, parties get right to assign any of the right and obligation to the third party. The assignment to third party is valid when done as per the term and condition in the given agreement. Otherwise, it will be invalid. While drafting the contract or agreement, you need to also write the condition attached to the assignment clause. Assignment and transfer in case of individual product. In case where professional service is rendered, and then in such case the recipient of the professional service will not like to be assigned to the third party. So let's see this example to understand it more clearly. So suppose N is a renowned teacher and he has signed an agreement with a coaching company to teach for a period of 1 year. Suddenly, Mr. N met with the accident and he is unable to teach. Then in such a scenario, Mr. N cannot assign his teaching job to someone, as it requires personal skill which Mr. N has. Also, the coaching company will not be fined when renowned teacher is replaced with some other teacher, as it will affect the reputation of the company. In some cases, the parties are comfortable in assigning some right and obligation to the third party, not all. Such provision needs to be carefully drafted so that there is no confusion. Often non-assigning party want undertaking by proposed assignee to abide by all term and condition. For example, deed of adherence is executed by the proposed assignee as annexure to the agreement. So before drafting assignment clause, we need to take care of these important points. Whether assignment is possible in the agreement, list of category where assignment is not allowed, lock-in period during which assignment is not permissible, list of right and obligation where assignment is not allowed, check whether deed of adherence needs to be executed for assignee. Let's see how to draft the assignment and transfer clause. So here is the example. I am highlighting with this pink color. Let me read it for you. No part of this agreement shall be assigned to third party. Delegation of duties shall only be done with prior permission of the other party. All terms and provision of this agreement shall be binding on the parties and their respective heir, successor and permitted assignee. So in this way, you can draft the clause of assignment and transfer. Dispute resolution mechanism. Parties often make commercial agreement to grow their business, but due to some miscommunication or misunderstanding, there often dispute arise between the parties. That's why inserting dispute resolution clause is very important in an agreement. Relevance of dispute resolution clause. Because of dispute resolution clause, parties often resolve their dispute through arbitration, mediation, conciliation, etc. By using this method, dispute can be adjudicated within a year. Otherwise, through court system, it will take more than 2 years. Basically, dispute resolution clause gives the party option to choose the alternative method of dispute resolution. Otherwise, they have to mandatorily go to the court to adjudicate their dispute, which takes a lot of time, and also resolving dispute through court is costly. Precaution. So before drafting dispute resolution clause, the draftsman must check the nature of the business, the size of the transaction involved in a particular dispute, whether the transactions are international in nature, etc. Then only mention the dispute resolution clause and its type, whether it is going to be resolved through arbitration, mediation, and conciliation. For example, it will be unwise to suggest international arbitration for domestic dispute where the transactions are of low value. So be careful before drafting dispute resolution clause. Now look at your screen. A paragraph is highlighted with pink color. So this paragraph is dispute resolution clause in any agreement. You can also draft your own paragraph as per your needs. Let me read this paragraph for you. Any dispute between the parties shall first be referred to the director of both the parties. The director shall make all effort to resolve the dispute within 45 days. In case the director fails to resolve the dispute, then dispute shall be referred to sole arbitrator mutually agreed by the parties. The arbitration proceeding will be held in Delhi as per Arbitration and Reconciliation Act 1996. So in this way, in any agreement, we can draft dispute resolution clause. Completeness. So before finalizing the agreement, go through the agreement again to check its completeness. The final agreement should be self-sufficient and complete. Now let's see how to check the completeness of the agreement. We can check the completeness of the agreement by checking whether the all aspects of the negotiation between the parties are covered in the agreement or not. No scope of the future negotiation should be left. Not too many cross-reference. So basically what do you mean by cross-reference? Cross-reference basically means when you are referring to some other document. So in case you refer to some other document to know anything, then incorporate the entire text of that document in the agreement. But it will work only if the length of the text is small. Too many cross-reference. In case of too many cross-reference, kindly attach the document with the agreement and also mention a line regarding same in the agreement. Let's see these two examples on your screen. Such examples are often written in the agreement to regulate the completeness of the agreement. So let me read it for you. This agreement is complete agreement and nothing is left respect of the subject matter. Let me read the second example. This agreement is complete agreement and it replaces all prior oral written understanding between the parties. No term and condition is binding between the parties except mentioned in the agreement. Suppression of earlier arrangement or agreement. So we have often seen that before the agreement is executed by the parties have prior arrangement before the execution of the agreement. This arrangement might be in the form of oral or in the form of some written text. But after the agreement is executed, this all oral arrangement or some sort of written in a piece of paper will be null and void. In India, we have often seen that the state government organize investor summit each year. These investor summits are organized to attract the investment in their state. Now, if the big corporates are interested in investing in the state, then they execute letter of intent or memorandum of understanding or non-disclosure agreement within a day with the government of the state. So why they execute this MOU or LOI or NDA? Basically, these are executed as they are non-binding in nature and often provides time frame to execute the fresh agreement. Now the question is, why these big corporations sign MOU, NDA and LOI before the agreement? Why don't they directly sign the agreement? So let me answer you by giving some of the reasons. First, the MOU is not binding in nature. So they are not bounded to invest in the state. The second is the MOU can be signed within a day between the parties. So it is very quick. The third is MOU, NDA or LOI often play an important role in determining the term and condition of the main agreement, as the main agreement are binding in nature. And there are several other reasons like the parties want to assess the ground reality before executing the main contract, as the main contract is binding in nature. After determining the term and condition, the parties execute fresh agreement. And this MOU, LOI or NDA stands null and void from the date of execution of the agreement. An agreement is executed only after the term and condition are determined by the parties. So this MOU, LOI and NDA plays important role while drafting the main agreement. That's why they are executed first. After the execution of the agreement, this MOU, LOI and NDA are useless. A statement regarding this is often written in the agreement to avoid any further confusion between the parties. Let's look at your screen and see both the highlighted example with pink color. A clause is written in this manner. I am reading the clause right now. This agreement replaces all kind of previous arrangement between the parties. Now let me read the second example. The agreement is complete and between the parties, and any prior understanding between the parties stands null and void. Amendment. If the situation demands, the party can amend the agreement, but the procedure for amendment should be mentioned in the agreement. Otherwise, they cannot amend the agreement. The amendment in any agreement is possible only if the agreement require few changes. If the agreement require a lot of changes, then executing the fresh agreement is better option. Otherwise, it is difficult to understand the agreement. The amendment replaces only the portion of the agreement. It doesn't replaces whole agreement. But to understand the agreement after the amendment, one have to place both the amendment agreement and the original agreement. Let's see the case of too many amendment already done in an agreement. So in case of too many amendment done already in the agreement, then executing fresh agreement is a good option, because amending again the agreement will make it difficult to understand the agreement itself. It will create a lot of confusion. So executing fresh agreement is a best option. Now let's see how to title the new agreement. We can title the new agreement as amendment and restatement agreement, revision and restatement agreement, revised or restated joint agreement. Please remember, the name or the title of the fresh agreement will depend upon the name of the already executed agreement. Now let's see the concept of mutual consent. The agreement can only be amended by the mutual consent of the parties or their representative. They cannot be amended unilaterally. Similarly, all fresh agreement can only be executed by the consent of all parties or their representatives. Also, the amendment of the agreement or execution of the fresh agreement should be in the form of agreement itself, and it should be written. No requirement of mutual consent. In some cases, the parties solely can amend the agreement, but such power should always be mentioned in the agreement itself. For example, we have often seen the most important term and condition of a bank often change, and we don't bother about this change till the time these changes are not drastic in nature. We continue to use the service of the bank. Till the time we continue to use the service of the bank, it is deemed to be we have given the consent. Similarly, the website privacy policy and cookies often change. Don't even bother to read once. So in the above two examples, we have seen how the service provider solely can amend the agreement without approval of the user. This happens till the time user doesn't object to such agreement. We often keep using the service and it is deemed to be we have given the consent. Now let's see these two examples. Such lines are often written in an agreement to regulate the amendment of the agreement. So let me read first for you. No variation of this agreement is deemed to be effective unless it is made in writing and signed by all the parties to the agreement. So in the first case, amendment requires all the parties to give consent and it should be in written. Let's read second example. This agreement can only be amended by two-thirds of the parties agreed to amend the agreement and it shall be in written. The example says that the consent of two-thirds of the parties is necessary to amend the agreement and it should be in written. So we can write our own version as per the need of the agreement to regulate the amendment of the agreement.